Hi everyone, and welcome to the Family Law webinar held by KPA lawyers. I'm Emily Banks. I'm one of the family lawyers at KPA. We also have three other lawyers here today, and I'm going to let them introduce themselves, starting with Sasha.
Hi, my name is Sasha Frone, and I strictly practice family law at KPA.
And Karishma.
Hi, I'm Karishma. I also strictly practice exclusively in family law at KPA.
And Preet.
Hi everyone, I'm one of the partners at KPA and I practice in family law as well as a few other areas.
And I did not say what I practice in. I practice mostly in family law. I do a little bit of criminal defense and a little bit of personal injury. Next, we're just going to talk a little bit about KPA. So we are a full service litigation firm. The four of us practice mostly in family law, as we've said, but we have a very great civil team who does everything from human rights tribunals, employment law, cannabis law, small claims, business law, real estate, construction liens, and debt collections and wills. And as I said, I also do criminal defense work. Right now, we are offering free consultations during COVID-19. So if you have any questions that don't get answered during this webinar, or you have something that's a little bit more specific, you can always book a consult online. You can go to our website at kpalawyers.ca, and then there's a button that says book a free consultation. And with that, we're going to go to the next page.
All right, thanks, Emily. So in terms of some alternatives to court, especially during COVID-19, so a lot of people assume that if you're going through a separation, that the only option is court, and that's not the case. So on this slide, we have a number of what we can call alternatives to court or different process options. On the left side of the spectrum are options that are the least expensive. They will result in the quickest resolution of your matter, and both parties get to retain as much autonomy as possible. As we go to the right side of the spectrum, these are more costly options. Essentially, the parties will lose autonomy, and these could be quite time consuming in terms of arriving at a final resolution. So when we talk about a kitchen table discussion, that's the idea of you sitting down with your ex-partner, either in person, over phone, or over email, for example, and discussing all of the issues pertaining to your matter. So for example, if you have children together, you and your ex-partner might be able to have a discussion with respect to what does the parenting schedule look like now that we're separated. So if you're able to sit down and go through all the issues and come to a resolution, what you can do is then take that, what we call kitchen table discussion, to a lawyer to draft what's called a separation agreement. A separation agreement is a contract between you and your ex-spouse that stipulates all of the issues and how you've planned to resolve them. And in that case, both parties will need to get what's called ILA, which is independent legal advice. As we move towards the right end of the spectrum, we have what are called lawyer-lawyer negotiations. Most of the family lawyers at KPA engage in this type of work. So the idea is that both parties get lawyers of their own, and the lawyers assist the parties in coming to a resolution on all of the issues. Again, the idea is that once you've reached a resolution, one lawyer typically will prepare a first draft of the separation agreement, and both parties will then sign and everything is done. Collaborative family law, that's a new and growing area of law. Collaborative family law requires that both parties sign a participation agreement. So the idea is that both parties agree at the very outset that they're going to participate in this process and that neither party is at some future time going to then take this matter to court. With collaborative family law, both parties are expected to be amicable throughout the process. Both parties typically have lawyers, and different third parties are involved in this process. So for example, if there are challenging parenting issues, the parties might jointly retain a parenting coordinator that can assist with deciding how custody and access issues are going to work. So decision-making and parenting schedules. If one party or both parties, for example, have a business, the parties might jointly retain a business valuator. So the idea here is that it's a collaborative process and various third parties are involved depending on the needs of a specific family. Mediation is a great option, and it's something that I strongly advocate. The idea with mediation is that you have a neutral third party who's called a mediator. A mediator doesn't have to be a lawyer, but oftentimes they are. It could be a social worker, for example. And the mediator acts as a neutral third party in the sense that They won't give legal advice. They can only provide legal information to the parties. And they try and facilitate communication between the parties to help them arrive at a resolution on all of the issues. With mediation, this is something that can be done during COVID-19, and it can be done over Skype, for example. But traditionally, mediation involves both parties either being in the same room with the mediator, with or without lawyers, or you can have what's called shuttle mediation. So the idea is that both clients are in separate rooms with or without lawyers, and the mediator would then shuttle between rooms to facilitate communication and help the parties arrive at a resolution. Once mediation is completed, if all of the issues have been resolved, or if some of the issues have been resolved, the mediator would typically prepare what's called a mediation report, and it's a summary of what the parties agreed to during mediation. The idea with mediation is that once it's complete, both parties would then take the mediation report to their respective lawyers to receive what's called ILA. Again, that's independent legal advice. The lawyers will then draft a separation agreement. As we go towards the right end, there's arbitration in court. And in the middle between mediation and arbitration is what we call MedArb. During COVID-19 especially, several of us, myself included, have been encouraging parties to participate in mediation arbitration, especially because courts were closed and we're only hearing urgent matters. So the idea with mediation arbitration is that the parties, again, lock into this process. They start off with one professional. This professional is both a mediator and an arbitrator. As I said previously, a mediator doesn't have to be a lawyer. Anyone can call themselves a mediator, so you want to make sure that you retain someone who is going to have the skill set necessary to help you resolve your issues. Whereas an arbitrator is an experienced family lawyer that has taken certain courses. But the idea is that you retain one professional that acts both as a mediator and an arbitrator. As a mediator, they try and help the parties achieve resolution amongst themselves through settlement, where the parties themselves are crafting a resolution. And then with arbitration, the idea is that it's almost like you're hiring a judge privately to decide the issue. So with MedArb, what I really like about it is you try and resolve things through negotiated settlement. And if the parties aren't able to resolve all of the issues, or if they're only able to resolve part of the issues, then the issues that couldn't be resolved then switch to arbitration. So arbitration, it's almost like you're paying a judge privately, as I said, and the arbitrator will hear from both sides, and then they will impose a decision, and that decision is just as binding as a court order. And then of course there's court, which most people are well familiar with because they've seen various Hollywood shows. And the idea is that you're essentially saying to a judge, we can't come to a resolution, please make a decision for us. Those are the various alternatives to court.
Okay, so we got a bunch of questions emailed to us, and we're just going to start addressing some of those if the panelists are okay with that.
Yes,
Okay.
we can start with the question and answer period, but before we get to that, I just want to let everybody in the info session know that the courts have opened their services further than urgent matters today. And if you have any specific questions about what the courts are hearing and how they're hearing it and what the procedural aspect of it is, you are welcome to ask the questions. I'll try to address some of the releases that the courts have released today while in discussion, but we'll go back to Karishma for some question answers.
Sure.
Josh, can you turn, there we go, perfect.
Thanks, Preet. Thanks, Asha. So one of the questions we received today was from Dave Brown, and it's basically a question about what happens after you already have an order, and if you can do anything to either change that order or set aside that order. It is quite a long question with lots of facts, so I would encourage Dave to book a consultation with us, but in terms of setting aside an order or changing an order, we can do that via motion to change. And this question, and I don't know if the panelists have had a chance to look at it, but I'm not quite sure if it's asking to enforce the order or if it's asking to change an order. So maybe that's something that Dave can contact us and clarify what he needs help with.
Then just to add on to that, just a general term about motions to change, if what you're trying to do is actually change the order, is that you need to prove to the court that there's been a material change in circumstances. So it can't be that you just want something to be different. You have to show that it is required to be different and that your order no longer applies based on the current situation. And generally, you have to have actual evidence of this, and it shouldn't be too far back. Let's do some of the questions that are being sent to us on the Q&A so that we can mix up between that and the previously sent questions. Preet, you were going to answer one that was sent first?
Yes, I've already answered in writing, but I will expand on it. An anonymous attendee requested some information about if a separation agreement has to be signed off by a lawyer. Technically, no. However, I would not encourage anybody to sign a separation agreement without obtaining independent legal advice. And that is a certificate that is signed accompanying an agreement. It's called independent legal advice. So I would not advise you to sign an agreement unless you have had a lawyer look over the agreement to ensure that your rights are protected in your separation.
Yeah, and I'll just tack on to that actually. So the most common reasons why a judge could say that an agreement isn't binding if it's ever challenged is, number one, there wasn't financial disclosure provided by one or both parties. And number two, it's very easy for a judge to say, well, I don't find this agreement to be binding because one or both parties didn't have legal advice. So it's easier for them to say, well, I didn't understand what I was signing at the time that I signed it because I'm not a lawyer. I didn't obtain advice. So yes, as Preet said, it's not a requirement that legal advice be received, but if you're going to go through the process of maybe getting a lawyer to draft something, you want to make sure both parties have signed it because you want to make sure that that agreement is going to be upheld at some future time if it's ever challenged.
I think our partner, the other partner at KPA, Ryan Keeney, he is actually handling all of the IT infrastructure, and he has mentioned in the group chat to all the panelists, if you wish to raise your hand, use the raise your hand button to ask the question through your mic. He can put you into our conversation, and we can have a discussion while we all discuss everything. We also have a mediator with us, and yes, we do recommend that clients get independent legal advice, and we don't like to sign agreements without clients getting independent legal advice. And yes, you can also write the questions if you do not wish to speak with us. So let's move on to the next question. It's one of the very first questions as well. If I decide to leave the condo and find an apartment, will I lose anything, especially when there is so much stress in the home?
So I can take that question. So let's say you own a matrimonial home with your spouse, and you decide you need to leave in order to have a healthy relationship with your ex-spouse or your children. You're not losing anything. You have your rights into your property. The only thing that we have to tell you is that you will be required to still be making some payments towards the upkeep of the house. You want to make sure that you are keeping your rights and making sure that you're paying as much as possible towards the house. This doesn't include things like the internet or utilities because you're not using them, but it's mostly the mortgage, property taxes, that kind of thing. If you don't pay them, you're still entitled to your portion of your equalization. However, the amount could be changed at a later date based on post-separation adjustments if one party has been doing the full upkeep of the property.
All right, thank you, Emily. The next question is, what happens when school opens and when one parent wants to send them back to school and the other one doesn't? I think the question is very vague, but it could start with the fact that what custody arrangement you have with your spouse or ex-partner or common law partner, or a number of different ways relationships exist nowadays. So it depends on the arrangement you have for custody. If it's joint custody, sole custody, who gets decision making, if you currently have an order in place or not, what the order says. So perhaps, Mary, if you wish to get specific detailed answers for your question that you've posed to us, you can book a free consultation with us at the moment, and we can help you with that answer. Okay?
So Mary's been added to the webinar.
Oh, perfect.
So Mary, if Preet's answered your question, then that's great. If not, if you want to add a little bit more, then please do so.
Is it Ryan that needs to add her?
She's already been added.
Here.
Okay.
Mary, can you hear us?
Yes, I can.
Oh,
Thanks.
perfect.
Yeah, it's actually my grandson, and the mom and dad share custody 50-50. And when schools do open, my grandson has severe asthma, and my daughter's afraid that his dad will send him back to school on his time, and she doesn't necessarily think that he should be going to school since he's at risk.
Mary, do you know if there's a custody agreement in place?
The custody agreement is 50-50.
I'm sorry,
I mean,
did you miss
is
how
it-
old the child was?
He's 9 years old.
Okay, so I think there might be more than family law to this question as well. There are guidelines in the law that requires children to attend school unless there's alternative arrangements. I am, if you want to book a consultation, Ryan actually does practice in the area of law. He could probably assist you in answering that question. But in terms of family law, I don't think we can provide you too much besides the custody arrangement.
Okay, because right now the government is saying when schools do open again, that it's optional for kids to go back to school.
Yeah, so
So-
if the government is saying that, then yes, that could be an option. And if you fear for the safety of your child, again, you can take the assistance of the court system to get an order that allows you to do what you wish to do, not send the kid to school.
Yeah, and one thing I would add, Mary Ellen, is that you could get a note from the physician, so the family doctor, saying that he does have asthma, and that because of that, if the doctor's willing to put something in writing, that always helps, because otherwise it's often he said versus she said, unless there's some form of supporting evidence. So because the fact that he has asthma, and it's just known with COVID-19 that people that have those types of health issues are more at risk for contracting the virus. So I think that's very reasonable. But if the dad is going to make an issue about it, then I think it helps having some form of substantiating evidence.
Yeah,
Thank you very
the
much.
Education Act actually does excuse students from attending school if it's by reason of sickness or other unavoidable cause.
Mm-hmm.
The Section 21 compulsory attendance section has a lot of exceptions, and that's one of them.
Thank you, Ryan. I knew Ryan knew the answer to that.
Thank
No
you.
problem.
You're welcome.
All right, so John did have his hand up, but he's taken it down. But he had sent us a previous email with his question, and it was about child support. John, I'm not going to go into all the details because it is a very personal issue that you've emailed us. So for your specific case, I'd say please do book a consultation. But in general, his daughter is 22 years old, was attending college. Most likely isn't attending college at the moment. Doesn't really have that much of a relationship per se with his daughter, or doesn't know all of the information. And he's been paying child support for the last 15 years. So John, as you probably know, child support is the right of the child, and it does extend after you're 18, as long as you are either in full-time school or for a reason of not being able to withdraw for parental control because of disability. From what you said, most likely you could have your child support terminated. You said that you have requested it. I'm assuming that you requested it from FRO. they won't be able to terminate it unless your ex agrees to that. If she doesn't agree, then you're going to have to bring a motion to change in order to change your child support obligations right now. What I can say is that FRO at the moment is not doing any enforcement. So if we never advise for you to stop paying support, but if that's something that you decide, most likely FRO won't be enforcing it. But you will need to bring a motion to change. But unfortunately, depending on what court you're in, they're not really starting new matters. So if it's coming to a point where it is a dire financial need for you to stop paying support, then you might be able to bring a motion. Other than that, I'd say the better thing to do is to contact a lawyer, have a consultation, maybe start drafting all of your materials to give you time to get it all together. And then as soon as the courts are allowing new applications to be brought, then it can be issued and served immediately.
Thanks, Sam. So one of the other emails that we received was from Ashley, and she asked basically what's happening with COVID and orders that are already in effect prior to COVID. So her questions are whether her partner or ex-partner is still obligated to pay his percentage of childcare costs. And number two, is she right in maintaining that court-ordered scheduling during COVID? When she says court-ordered scheduling, I believe she means court-ordered parenting time. And as recent endorsements have said, that any court orders, outstanding court orders prior to COVID, still are in effect, still should be adhered to as long as it's in the child's best interest. So in that sense, as long as, he's not exposed to the virus and you're not exposed to the virus, then access should continue as the order stipulates. And absolutely, he's still obligated to pay his percentage of childcare costs.
Yeah, that was good. Next one.
Emily, you could perhaps answer this one. It's by an anonymous attendee. Can an adult child put a restraining order against a parent who continuously harass them by email?
Definitely not something that I've heard before happening in family law. But adult children can go back and ask for child support, so it's possible. But most likely, if the parent is harassing them and they've asked the parent to stop contacting them, the better option is to actually contact the police because they would be able to put a charge for harassment. Or you could do a private prosecution and get a peace bond against your parent for them to stop contacting you.
There we go. The only reason I put that question to you is because Emily practices criminal law and she is our only lawyer in our office that practices criminal law. So I assumed that was an area of criminal, but I see how it overlaps with family law a little bit and it's not solely criminal. Let's go to the next question. Can a father get full custody of a minor daughter? Of course, a father can get sole custody of a minor daughter, but there will be many questions and arguments to be made prior to that being the final arrangement. And perhaps everyone else can add on what kind of things to be raised when you want full custody and when you do get full custody.
Well, I would say the default in Ontario, and we have lots of clients or people that ask us this question. So a lot of people will just assume that mothers will always get sole custody and mothers will get primary residence with the children. That's not the case. So the default in Ontario is that if two parents have separated or if they have a child together and they're not together, then it's going to be joint custody, which means joint decision making. So it's not day-to-day decision making, it's decision making with respect to major medical decisions, maybe extracurricular activities, religious upbringing, and education. And the default in Ontario is also, with respect to parenting, is it's going to be 50-50. For younger children, for example, if a child's being breastfed, a 50-50 access schedule might not make sense. But typically the default is 50-50 and joint custody.
So I just want to jump in real quick. We're getting a lot of emails regarding access during COVID and when one parent is withholding the other child. And I don't know if the other panelists want to jump in on their stance on that, but again, recent endorsements have all stated that access should continue pursuant to any outstanding court order as long as it's reasonable and in the best interest of the children. There's no reason to unreasonably withhold access, and that is definitely something that, you know, courts will hold you accountable for once courts reopen and a judge does hear your case. It is also grounds for an urgent motion if you are unreasonably withholding a child when there is an existing court order. So, you know, if anyone wants to jump in on that.
Yeah, so I was going to say, so if one parent is knowingly not practicing social distancing, or they're, you know, they're going out in the public and they're not taking the proper safety precautions that the federal government has released, then that could be grounds to withhold access, but there has to be proof of it. So again, when it comes to court, it's he said versus she said typically, or, you know, person A said it, person B said it, unless there's proof. So if one parent is able to demonstrate that it would not be in the child's best interest to have parenting time during COVID-19 with one parent because of various reasons, then there could be a justification for withholding access. But as Karishma said, the understanding is that all, whether it's in a separation agreement or whether there's a court order that stipulates how access is to occur, that needs to continue. And it's only with extenuating circumstances that one parent would be justified to actually withhold access or to modify the access that it was existing prior to COVID-19.
For example, I'm just going to add on to that. Sorry, Preet, you looked like you were about to say something. If a parent, for example, has had travel in the recent weeks and is under a mandatory 14-day quarantine,
right,
probably not in the child's best interest to see that parent. In that situation, maybe we can schedule a Skype or a video call or a Zoom call to kind of facilitate access in the meantime so that the child is not 2 weeks without seeing a parent that they would normally see. So that's an example of maybe when it would be reasonable to withhold access.
Thank you, guys. We have Amy Banks who wishes to join the call. Ryan, if you can connect Amy Banks in.
Hi, Amy. You should be able to speak now.
Hey.
Can you hear me?
Yes.
Yes.
Okay. I have a very specific question. Okay. It's easier for me to talk than type. Okay. My fiance has his son every other weekend as per court order. This is his weekend to have his son. Now, he communicated with his ex about picking up his son early on Friday, and she agreed. And in his court order, if it is a long weekend, he can have his son from Friday night through till Monday. Now, when he asked about picking up his son early, he didn't realize that this was a long weekend. And she agreed, saying that yes, he could pick his son up at 4:30 instead of 6:30. Well, when he realized that it was a long weekend, he went back to try and correct it to have his son on the Monday as per his court order, and she is saying no. Does he, because they use the family wizard app to message back and forth, so everything's documented. She said yes, but he went back and said he didn't realize that it was a long weekend and he would like to go back and have his son for the holiday Monday, which is he's entitled to as per his court order, and she is saying no. Does he have any grounds to have his son on that Monday, or would what he wrote in the Family Wizard Act take priority over what is in the court order? Does that make sense?
Yeah, so just so I understand, Amy, so he didn't realize, like when he had messaged her in the app and Family Wizard, he didn't realize it was a long weekend. So really he gets an extra day with his son.
Correct.
And access would terminate. Yeah, so regardless of what he wrote, I mean, he made a mistake, the court order stands. So she doesn't have any basis for shortening his weekend. I mean, I would probably, maybe my panelists wouldn't agree, but I would just keep my child and just give her notice that it is in fact a long weekend. Pursuant to the court order, my access is to be extended until Monday. He's being compliant with the court order. So I don't know what basis she has. He made a mistake.
Also the issue is Monday is also his son's birthday. And because it's also in their court order that every other year, so for him, it's on odd years that he has access to his son for 3 hours on his birthday. And she's trying to say he knows it's not in any other weekend, he wouldn't be able to see his son, but because specifically this is a long weekend and it is his, she's saying no, that Jack, that's his son, would have to be returned Sunday, and now he feels compelled to bring his son back for fear that she's going to call the cops on him.
Well, it's a little
And that
concerning
the
that
cops are going to show up at our house on Sunday night if he doesn't return him.
So it's a little concerning that the agreement has contradictory orders in it because of the birthday and a long weekend. Obviously, that can happen pretty easily. Most of our orders that we write do say that access would continue into a Monday holiday.
Okay.
I'm with Sasha still that it would probably still remain his access weekend, maybe return the son a little bit earlier than he normally would, so that it would be half and half for the bathroom for the birthday. There's really not. Is the access police enforced in the court order?
Pardon?
Is the access police enforced in the court order?
That I'm not sure of.
Yeah, Amy, sorry to interrupt. What I would suggest is that you can book a consultation with one of us. I'm sure there's some time slots available tomorrow. And then if you had emailed whoever you booked the consult with, if you email us a copy of the court order, it would be a lot easier for us to understand which clause takes precedence. Because as Emily said, it seems like there might be some contradictory terms within the court order. So that would be probably the best way to get an answer for you.
Okay.
All right.
Thank
All
you
right.
for
Thank
joining
you.
us,
I will
Amy.
let him know. Thank you so much.
You're welcome. Thanks for your question.
We have another question from an anonymous attendee. I've told my husband I want a divorce about a month ago, but we haven't actioned anything due to COVID and the added stress that may impact our kids, 9 and 5. Is it best to wait until things open up? My plan is to work with a mediator. So you can work with the mediator now as well. There's many mediators are offering virtual assistance. We can do shuttle mediation. So you don't necessarily need to wait until things open up to start getting your divorce rolling. So that's definitely something that we can do without having to wait for the courts to reopen.
Yeah, and I'm just going to add on to Krishna's comment about that. So I think maybe the question also stems from the thinking that, if we've separated but we're still living under the same roof, many people live separate and apart. That's the test. Have you been living separate and apart? That determines the date of separation. So you can absolutely start the process, but be still residing together within the same home.
All right, I think we have another raised hand. Ryan, do you mind connecting Marion Jacobin? Marion, can you hear us?
Yes, actually, I did put my question down as well. I would prefer, actually, is there any way I can, I don't know who's listening in on this call, so I was wondering whether I could be anonymous somehow.
Yep, so it's just all we see is your name, Marion. We can't see your face or anything like that. There's no other identifying information.
Okay, but yeah, the name is pretty clear. So yeah, actually, I wanted to check about whether a drinking problem would be sufficient cause for shared custody um, to be prevented.
So when it comes to custody, so as I said, so the default is always shared custody, just like shared parenting time. But the test with children is always what's in the child's best interest, and that's how judges make decisions. So if the other parent's drinking is an issue to the point that he or she is unable to parent the child that's in their best interest, then yes, that could definitely be an issue. So depending on the age of the children, there'd have to be, again, some evidence. So as you can imagine, many people make all types of allegations in order to raise claims of custody or access in their favor, but there has to be actual evidence to support your position when it comes to that. So if the child is very young and the parent has a history of drinking and driving and they've gotten into accidents, or while a young child is in their care, they've passed out, for example, that would help support your potential claim. So there have to be specific examples.
Okay, thank you.
Thank you, Vivian. Ryan, can you connect John in, please?
Hi, John.
Hello, ladies. Thank you very much for putting on this free webinar.
Very welcome.
It's unfortunate that I didn't find your firm 15 years ago, but I know the separation agreement. My court order says that I will support my daughter up to the age of 22 and until she gets her first diploma. My question is, for the past month, I'll be totally honest here, I had no idea what was going on. She OD'd. She's in a psychiatric facility. She's been living on the street. And I mean, I love her dearly and I want to support her, but I made an application to FRO to terminate the support. My ex-wife will not agree to that. She wants the money. But my question is, if she's not attending school and she's not living at home, is there any chance, I don't know what the procedure is to terminate the support?
Yes, so John, you can bring a motion with the court requesting that relief. So the Family Responsibility Office will not do anything unless the opposing party either agrees to allowing you out of the agreement, or in the alternative, a court orders it. Given the situation that you've provided me, I don't see why a court wouldn't order. She's not living under the roof with your ex-spouse, and she is not in school. There is no reason for you to be continuing paying child support in those circumstances. But if you want to speak a little bit more about this issue, you can book a consultation with us, because I think we can probably get more information and respond to you in a very specific manner. But in sum, what you do is you bring a motion to the court and get a court order.
Okay. I'm in Huntsville, Ontario, so the court order came out of Hamilton.
And where does your ex reside and the child reside?
Caledonia.
Caledonia. So currently courts are remote, and if you wish to retain, like Sasha at the beginning of the seminar, webinar, she had mentioned limited scope services. So that is something we encourage as well. It saves our clients a lot of money. So what we do is we do the drafting for you, we do all the paperwork for you. And what happens is you actually file the paperwork in your local court. And at the moment, courts are accepting everything online, so it wouldn't be a problem for us to assist you there as well. But if in the near future courts were to open again, like usual, publicly, you walk in and you do all the activity that needs to be done in the court, then at that time, what we would say is we do all your paperwork. We will prep you how to appear in court. and you go do that yourself. In your matter, it's something that you are capable and able, most people are able to do something like that on their own with some advice from a lawyer.
Okay, I really appreciate your answer and feedback, and I thank you for taking the time. I know lawyers aren't cheap, but it's nice that you're providing a free webinar, and you did answer my question, so I will try to get a hold of Sasha tomorrow, discuss a little bit more, find out what the costs are, and congratulations for being well and staying safe. And,
Thank you for the kind words, John.
Thanks. You have a
That was very sweet.
All right, next question, guys.
So there's a question from Crystal Green. It says, in a common law separation, can I take more cash if he is taking more expensive physical possessions? And or are there online services you recommend for splitting assets in a common law separation? So Crystal, there's a big difference of being common law and married for dividing assets and debts. When you're married, you have to do equalization. So everything both of you own is equalized. It's all of your assets and all of your debts. When you're common law, the only things that get separated are things that you have jointly, either in joint in name or where you've had a joint family venture in getting that asset or that debt. So I'm not quite sure what you mean by taking more cash or expensive physical possessions. It would be what the ownership is. If you have a joint account, that should be split 50-50. But I think this is going to be a more individual kind of question. So maybe you can book a consult with one of us so that we can help talk about your specifics.
So just so all the participants know, we try to answer every question as much as we can without going into too much detail so that our answers are able to provide information for everybody listening. When it becomes very specific, we do recommend that you book a consultation, because that specific situation is only helping you and it's not really providing general information for everybody listening. And we'd like to have enough information in the time we are here online so that it can assist everybody and not just one person in the group. And if you do want the assistance one-on-one, again, we are offering free consultations, so book us online. You could just simply visit our website and book us online, and we'll be able to speak with you on a one-on-one call and answer your very, very specific question. So I'm going to read the next question from Jillian. What happens to child support while child, 18-year-old, is living away from home during post-secondary schooling? Am I required to pay for 50% resident costs, tuition, and child support to the mother?
That's a really good question. When it comes to post-secondary expenses, it is very fact specific. So typically what happens is if a child is attending a post-secondary institution away from home, so they're not living with either parent, the cost of residence usually offsets table child support. So I'll back up a little bit. When it comes to child support payments, there's two categories. So there's what's called table child support and Section 7 expenses. So table child support is what we typically hear when someone says, oh, I've been paying her, I've been paying him, let's say $1,000 a month. That refers to table child support. And that amount is dictated based on a person's income. So you plug in the income, let's say for one child, and it spits out a number. That amount should be paid every month, and it varies dependent on a person's income. When a child is living away from home, so for a university or college, for example, it's typically 8 months in duration. So if a child is living on residence or they've rented a home off campus, for example, then for the 8 months that they're living away from home, typically speaking, and again, it depends on the facts of the case, but typically speaking, table child support would not be paid for those 8 months. They'd only be paid for 4 months when the child moves back to their primary residence for the summer months. The cost of residence and meal plans, etc., those are what we call Section 7 expenses. And those are typically shared between the parties proportionate to income. So sometimes we have cases where a parent is paying table child support for 12 months while a child is living away from home attending college or university, and they're also paying Section 7 expenses, which includes the cost of residence and food and textbooks and laptop, et cetera, and tuition. But there could be the argument that the support recipient, so the person collecting table child support, is double dipping, because that parent, the payor, is paying table child support, which includes basic necessities, food, clothing, and shelter, and they're also paying for residence fees. So there typically could be an argument that table child support shouldn't be paid during that time. Sorry, that was a very long-winded explanation. But the idea is typically table support could be paused during the 8 months while a child is attending school, provided that parent is contributing towards residence or accommodation of some sort.
Thank you, Sasha. Moving on to the next question. I bought a house during the marriage, but it was bought under my name and the house title is under my sole name. Brackets, we have maintained separate finances during the marriage. In simple and short, a house bought during the marriage, and if you live in it, is a matrimonial home. Despite who's on title, it will get divided in the marriage. Continuing with the question, my husband has also bought a home under his name in the USA. Do I need his consent after separation agreement is signed for my consent house if I want to sell the home? So I assume what this anonymous attendee is asking, do I need his consent to sign the documents for the sale of the home if we've already come to agreement in a separation agreement? And in the separation agreement signed and witnessed without using lawyers, it says I own full rights to the house. This is where I will always say, do not sign a separation agreement without a lawyer looking at it. You wouldn't get the plumbing in your house done from a person who's not a plumber. I wouldn't sign a separation agreement without getting a lawyer to review it. Because what I see in that description of the question itself is a lot of things that may go wrong. My panelists can also join me by answering that, but that's my strong opinion about a separation agreement and it being signed without having it reviewed for independent legal advice by a lawyer.
I second that opinion.
Yes, and for your specific question, I would suggest that you book a consultation. We can try to bring in also our real estate lawyer, Barbara, to see what is exactly written in your agreement and if it's possible to sell this property now without his consent.
Mm-hmm.
Oftentimes, separation agreements include releases, as my panelists know, but again, like Preet and Sasha and Emily all said, if it wasn't, if there was no lawyer witnessing it and it's just signed between the two of you, would really have to look at that agreement in order to fully assess the situation. So definitely that's something that you would maybe want to book a consult for.
All right, moving on to the next question. We have been separated for over a year, but continue to live in the family home and are looking to get a divorce/legal separation. What are the considerations that need to be taken into account when creating a separation agreement? My short answer to that is hire a lawyer.
So Preet, I was actually typing a response to this one.
Oh,
I think that's actually a really good question. And I think we have, or Emily, you want to just type it?
Well, I can read it out. So pretty much they said example custody finances. So I'm assuming there's children involved as well. So you need to deal with custody, access, child support, Section 7 expenses, possibly spousal support, equalization, and any possible releases. So pretty much everything that goes on in your life needs to be dealt with in this separation agreement. So I'm with Preet in saying that you're going to want to talk to a lawyer and see exactly what it is that you need to deal with for your specific situation. And then you can talk to your spouse first to see if there's anything that you can come to agreements with, see if you can make it amicable, as Sasha said previously, the kitchen table discussions. If not, then you can have a lawyer talk to you about it and then make a letter and try to start doing some negotiations on how to settle your separation.
We have a lot of questions actually about separation agreements.
I know.
Yeah, we have a lot of questions about separation agreements, and it's important to note that, like Emily said, you do want a lawyer to help you kind of navigate and narrow down the situations that are important in your family, because what you might find online on a, you know, a template of a separation agreement might not be what's best for your family. So they're definitely very specific to each family unit, and I'm sure my colleagues can attest to that. So yeah, definitely that's something that you would want to consider with a lawyer and see if you can come to an agreement with your spouse prior to meeting with a lawyer.
Thank you, Karishma and Emily. Next question. This is a long one, so bear with me. What can be done if a parent with primary care is allegedly practicing parental alienation, but the other parent cannot afford a lawyer? The parent convinced the judge that a parent who had been a stay-at-home parent was incapable of parenting and changed the care status quo and almost excluded the stay-at-home parent from even having visits. The parent making the allegations acts unilaterally and continues to keep the children from having anything more than a cursory relationship with their children, despite a joint custody order. It took years, but finally, after having another child and having sole care of the new child per FACS, I assume a Children's Aid Society, the false allegations were disproven. The accusing parent further restricted contact between their shared children and the other parent after the false allegations was disproven. However, legal costs are out of reach to fix the custody access order, and legal aid and duty counsel won't help.
Oh, there's an addition to that, I believe. In addition, my ex is unwilling to negotiate. I'm going to read the rest of it. Do you see that?
Oh, there it is. In addition, my ex is unwilling to negotiate. She spent approximately $50,000 in legal fees to try to stop our children from having a relationship with me originally, using her false allegations of my parenting abilities after I had been a stay-at-home parent. So only a full court order proceeding would likely help our children to have a proper relationship with both parents. So first and foremost, I'd like to say that if you have an order in place, everybody in here listening should follow it. There is no excuse for not following a court order or an agreement that you guys have agreed to. But if the other party isn't very much doing that, then your alternative is going to court. And I understand court can get expensive. And lucky for those people, we live in a jurisdiction where you don't need a lawyer to go to court. And you can do it yourself, but we do offer as lawyers, and I can't speak for all lawyers, but KPA, our lawyers do offer limited scope services. So we do have many clients that can't afford lawyers on a full-time, all across their file basis. But what they do is they talk to us when they need us the most during their litigation. And I know Sasha again, she did a brief introductory about limited scope services at the beginning. So we do offer limited scope services, and perhaps that's your method of getting yourself some assistance. And because your question was so long, I'm not sure if I've covered everything here. Parental alienation is not okay.
But to prove parental alienation, you need to have actual medical evidence. It's easier to say than to prove. And from what I'm understanding is that there was possibly a final order, and now you're trying to take it back. And that's why legal aid won't help. Before COVID-19, I'm not sure if they're doing it now, but they, with the restrictions to their budget, legal aid stopped helping out with motions to change. They were only helping with original applications. So maybe something that you need to go forward with your matter, like Preet said, on the limited scope. And then you can either have a lawyer help draft for you or attend just the court appearances for you.
Thank you. Someone else want to read the next one?
Sure, I'll read the next one. So this is from Marion. My relative's husband wants an amicable settlement separation agreement and is pushing for the sale of the matrimonial home. The wife has responded via independent lawyer that she's agreeable to the sale. is it recommended that she requests to use her own estate agent for the sale. So generally for the family law matter, you each want to have your own lawyers so you can make sure that your rights are properly represented for your separation agreement. But for actually selling the home, you usually use the same real estate agent. You can only have one agent sell a property, so you can't really have two. So generally what happens is that one party will suggest 3 or 4 real estate agents that they agree with, and then the other party will consent to one of them. And then you do the same for a real estate lawyer. So the real estate lawyer then holds the assets in trust after it's been sold. So after the payments of the mortgage and any other anything else that's on the property, the real estate lawyer then holds that in trust until a separation agreement is signed, and the 2 independent lawyers for the family law matter send the agreement and directions to the real estate lawyer on how to release the funds.
So we at KPA also do real estate law. So if anybody ever needed real estate services, they can always contact us. That was my, I'm a partner at the firm, and I need to tell everybody what we do. So we have Barbara at our office who practices in real estate and solely real estate. So she is always available to assist, and she's an amazing real estate lawyer. She will actually define everything that you're signing.
I can read the next one. So my ex has been ignoring my emails for paying upcoming medical, dental, and post-secondary education costs for my daughter, who is going to start in September. What should I do? So this is a good question. We would need to know if there's an existing court order, kind of the situation, your situation, what's happened so far, is FRO enforcing any payments? So there's a lot of things here that we would need before we can fully answer that question. I don't know if anybody else wants to jump in case they see something else.
So yeah, that would pretty much be my answer. You would need to either take it to court or hire a lawyer to do the initial correspondence.
Yeah.
All right, I have a question that was sent to us earlier today from a participant who is in the webinar. The question is, my trial has been moved due to COVID, was supposed to start Monday, and the lawyer's retainer has run out. After paying them more than $130K and them changing the trial strategy, they are trying to withdraw from the case. There is more than $1 million on the line. Can they really do that? So it's unfortunate that a lot of the trials are being delayed. They have announced that a lot of matters will be heard on an assignment court basis, which will literally be a court date where every trial scheduled during this COVID-19 pandemic will get a chance to speak to a judge and see how their matter is going to move forward. The date was, I believe, June the 1st. At one point, but currently they have adjourned that date to a non-date right now. They will be announcing it eventually. But
sorry. that was for Brampton Court, so each court has a different situation for trials.
That is correct. So that was for Brampton Court. I like to speak mainly about Brampton because we are very local to Brampton. We're 5 minutes down the street from Brampton Courthouse. So that's the situation about trials.
Yeah, then the second part of that question, Preet, had to do with the lawyer wanting to get rid of the claim.
So every lawyer does have the right to remove them from the record as long as the court is in agreement with that. We do find that so late in the stage on matters, sometimes judges will not allow lawyers to be removed, but it depends on the circumstances. It depends on the circumstances of each case. So I can't really, the reason I wanted to answer your question was to tell you that the courts have delayed the process for trial right now, but I'm not sure how to answer the rest of your question. If you wish to book a free consultation with us and discuss your matter a little bit further in terms of what the issues are at trial, and perhaps we can advise whether there is an alternative way to move your matter forward than trial, we would do our best to assist you. So if you wish, book a free consultation with us and we can give you further guidance.
I'm just gonna, Preet, if you don't mind, just add on to your point. Though we are local and centered to Brampton, right now most of the courts are running virtually, so we can assist no matter where you are across Ontario. We can attend virtually, so it's definitely something that we can help you with in terms of different courthouses and their operation during the pandemic.
And again, after the fact, if the courts do go back to normal, doesn't necessarily mean that we can't continue assisting you. There are limited services available, and we can continue those limited services across Ontario. Thank you, Karishma, for that, for correcting my Brampton comment.
So there was a question asked in the chat. It was about filing documents in possibly 47 Shepherd or 393 University. And 311 Jervis. You've talked about 2 OCJ matters and 1 SCJ courthouse. Really, for Ontario Court, they just released another notice today that they're asking for no one to attend the courts at all, and that they're not going to be dealing with new matters. However, you asked about filing your answer and responding materials. If an application was filed during this time, then there would probably be some way of responding. The judge most likely would have given some form of indication. If not, then make sure that you still serve your materials within the 30 days to make sure that you're following the rules as much as you can. But most likely you won't be able to do any filing specifically for 47 Shepherd or 311 Jarvis. The Superior Court is allowing some filing, and the notices have specific ways of doing the filing, including how to label your emails.
Sasha, you want to take the next question?
I'm actually not even looking at the questions. I'm letting you guys do it.
Oh.
I'm just jumping in as we go.
Sure. Okay, so I can read it. I had my ex-wife served with divorce papers today. I understand she has 30 days to contest. This is very similar to the question you just read, right, Em?
Mm-hmm.
It is not likely we will because we haven't been together for over 13 years. What if she signs them and gives them back to me before the 30 days expire? Do I still have to file any other forms, or do I just take my original papers and her response to the courthouse when it reopens? So tacking on to M's answer to the last question, where you are, what courthouse you are, and whether or not they're accepting filings online or in person, that you'd have to take that into consideration as well. And
so let me, if you don't mind, Karishma, I'll jump in. I've maybe read between the lines of this question.
Yep.
Divorce papers is a term that's used commonly across family law files, but I think there is some misunderstanding sometimes. Getting a divorce is simply getting a document, legal document that says you are no longer married and you can remarry, so that you don't commit any type of criminal offense. Sometimes divorce documents, also divorce papers, as the general public calls it, also address things like custody, access, financial division, equalization, division of debts and whatnot. So when Richard poses this question that his ex-wife would sign the documents and return them, there may be, if she signs them, it could mean that she's agreeing to the divorce if it's a joint divorce application filed. However, if you file a Form 8 application and someone signs it and sends it back, it's not necessarily signing the Form 8, it's actually sending you an answer Form 10 back. So it depends on what you've sent the other party and depends on what's coming back. But I also read the 13 years and there are some limitations. So I'm going to assume if it's a 13-year marriage, that has been over, chances are you've hopefully filed the correct paperwork, and she does not need to respond to them for you to move through with the divorce.
Yeah,
so as you can see, there's a bunch of questions that arise out of this scenario.
This is a good question, yeah.
Yeah, just clarifying what document was actually served and then what documents need to be responded to in relation to the issues.
Yes,
But
that
what-
would help answer the question itself.
But what Preet said, that if you just filed for divorce, she doesn't need to respond for you to proceed with your divorce. If that is what was filed.
Can you re-answer the question on leaving, please, and thanks.
I think that was the question about if you lose your rights to a property when you
So
leave.
can we pause this and answer the and get Richard in on the call? He's been waiting to get put into our conversation. Ryan, if you can help us put Richard in.
Hello.
Hi,
Hi,
Richard.
Richard.
Hey, ladies. Thanks very much for this free webinar. I appreciate it. And thank you for answering my question. I did serve her the 8A, and I served her all the court documents we had over the last 13 years involving our separation, custody, whatnot. Along with the paperwork, I was supposed to send her the response, which was the Form 10. And that was the one that she was supposed to sign and keep for, well, sign after 30 days or whatever. My question is, and I think you already answered it, if I'm not mistaken, is that if she signed it before the 30 days were up and gave it back to me, do I have to go forward and sign any other paperwork? Because they're asking if she kept it for 30 days plus, then I would have to file this 36A and other forms like that. But it's telling me that if she gives it back to me before that, I don't have to do anything except take the paperwork to the courthouse, I guess.
Richard, just to clarify, you sent a Form 8A?
I did everything online, and they sent me back the paperwork. I'm supposed to send her a copy of the 8A, the file for divorce, because I filed it online because there's no courthouse open down here in Brockville except for emergencies. And so I gave her the copy of the 8A and a copy of all the court documents that we had that I was supposed to send, plus the marriage certificate. And then I was supposed to send her a blank copy of the 10A.
Yes.
Or the 10, sorry, the Form
That's
10. And then now I'm just waiting for her to sign them. And it's not likely she's going to take 30 days because we've been separated for 13 years and I'm engaged to somebody else now. So
Richard, she does not need to sign anything back. Perhaps if you are in correspondence with her, it's not necessary for her to sign anything.
Okay.
She just needs to wait. If she doesn't wish to claim anything out of your marriage with her, and the children, all the issues with regards to the children, the child custody, support, and access have been dealt with in the alternative outside of court.
Yes.
There is no need for her to sign anything whatsoever. Although you're required to provide her blank copies, doesn't necessarily mean not anything needs to be signed. If she is silent for 30 days, you can file the second set of your paperwork, which is your affidavit for divorce.
Okay, and that's that 36A that we were talking about.
Correct.
Okay.
You can always call us at a different time, book a consultation, and I can guide you through the paperwork if you need.
Excellent. Thank you very much.
Not a problem.
And again, thanks for the free webinar.
Welcome.
Not a problem. Thanks, Richard.
Thank you.
Richard has like a good radio voice. I love it.
I know. I liked it.
It's very smooth.
So I'm going to go back to Emily because Emily remembered our anonymous attendee participants question. Can you re-answer the question on leaving, please, and thanks?
So I believe it's the question where she asked if she was going to be losing out any of her rights if she left the matrimonial home. The short answer is no.
Short answer
is no. If you are married and you are separated now, all of your assets and debts need to be equalized. That is from the date of separation. So if you own the property on the date of separation, it will be equalized no matter if you leave or not. However, it changes the amount of what you would get if the one party is paying for all of the expenses or not. This is what's called post-separation adjustments. So it's very case specific. So if you want to call in to get a consultation on your specific case, and if you feel comfortable of leaving or not leaving your matrimonial home, then we'd be happy to help.
Yeah, and I'm just going to tack on to what Emily said, because I think a lot of the questions that we get asked as family lawyers and consultations, especially if it's a matrimonial home, if I leave, can the other person bar me from re-entry? So a lot of people think, oh, well, he or she left the home, they haven't been there for months, so they have the right to change the locks, or well, they haven't lived here for 6 months, so they're not allowed to re-enter, and that's not the case. So unless, if it is a marriage, regardless of who is on title, the property that you were living in at the time of separation is called the matrimonial property, that it's owned and not a rental unit, for example. And so neither party can change the locks or bar the other person's entry unless one party through a court order or an agreement has what's called exclusive possession.
Perfect, thanks, Ash.
Mm-hmm.
There's a comment from Nancy that says, I think it's important to look at the child's needs as it is his birthday. Oh, okay, so I think that was commenting on the previous question about if the continuing access to the Monday.
I think you both, Sasha and Emily, when you guys weighed into that question from our live participant, you both did say that perhaps they can do a access day that is split in half. Perhaps he could drop the child off a little bit earlier than what is usual. So yes, we did kind of come to that kind of resolution of that.
Okay, next question. At what age do kids have more autonomy on what parent to spend more time with? Let's say a father and mother decide 50-50 custody. For example, if a kid turns 18, will they have a say in changing the amount of time they spend with one parent over the other? Then further, there's a adding of could a 12-year-old child make a decision of where they want to live. So first, I'm going to talk about the 18-year-old. Once they turn 18, the access schedule no longer applies to them. So they can decide what they want to do with their time and where they want to live. Going to the 12-year-old, so once a child is, sometimes 12 is a little bit young, it depends on the child, but usually when you're going up to 13, 14, 15, the court will take a child's perspective into consideration. At that point, you can get what's called the Office of the Children's Lawyer involved if there is a lot of disagreement between the parents. When a child is that old, then they will actually assign a lawyer to the child to hear what the child wants, and the lawyer will represent the child's wishes in the court matter. You can get the Office of the Children's Lawyer involved if the child is younger, but usually that is, they're a social worker who take a look at what the child is saying, but also all the collateral. So what both parents are saying, if there's grandparents involved, at the school, principal or a teacher or a counselor, any of those people. If CAS has been involved, they talk to everyone to see what is the best interest of the child and make a statement, a written report on what is the best interest of the child for that. They don't participate per se into the litigation when the child is younger. They just do the report, whereas when a child is older and they have a lawyer, they become part of the litigation and become a party of the litigation.
Yeah, I'm just going to tack on to that, Em. So as Emily said, it's like once a child turns 18, they can make that decision for themselves. And we do get a lot of questions saying, my child is this, like how old does a child have to be before they can make that decision themselves? So the general, there is no number aside from turning 18. But typically, a judge is going to say if a child is 15, 16, 17 years of age, it would be difficult to force them, if they don't want to go and see the other parent. But I've had a case where a child as young as 14 years of age, or I think 13 actually, was able to make a decision for themselves because Children's Aid was involved, OCL was involved, as Em said, Office of the Children's Lawyer, and the judge felt that the child consistently said, I do not want to have a relationship. In this case, it was dad. And they were very articulate in their comments, and they were very consistent. So a child that young was able to make that decision, but it really is dependent on the child's age. There is no magic age except for 18, and it really depends on the facts and that individual child.
Thank you, Sasha. We have Shia waiting to join the call. Ryan, if you can assist us again in joining Shia to our conversation. Hi, Shia, can you hear us?
They're muted.
Can you?
Perfect.
Here we go.
Yes, I can. Can you hear me?
Yes, perfect.
For a child to get a lawyer, can a stepfather get the lawyer for the child, or does it have to be the biological parent?
So I'll take this, guys. For a child to get a lawyer, that's getting the OCL involved. Now, you can't just hire a lawyer for the child. What happens is that once the matter is started, then you can ask the court for an order for getting the OCL involved. If a judge decides that there's a reason for that, then they'll do the order, but that still doesn't mean the OCL will get involved immediately. What happens is that the order goes to the OCL and the agency decides if they're going to get involved or not. It is actually up to the agency, not up to the judges. So unfortunately, technically what your question is can the stepfather get a lawyer for the child? That answer is no. You could be part of the family matter and then ask the court for an OCL to be appointed.
Yeah, and I'm going to add on to that. So what Emily's referring to, OCL, as she said, it's a government. If a judge requests it, doesn't mean it's going to be ordered, as Emily said. Other people might have the option of doing what's called a Section 30 assessment, which is pretty much a privately paid OCL report. So that's an individual, typically they have a social work background, and they're involved with the family, and they do pretty much the same work as an OCL would. It might be a bit more comprehensive because it's private, but they can be quite costly. So I've had a case where my client, prior to retaining me, her and her ex paid close to $30,000 for a Section 30 assessment. So obviously they vary in price, but if OCL isn't willing to get involved, then that's always an option for someone that's interested in getting what's called like a voice of the child report, or figuring out what's in the child's best interest with respect to custody and access issues.
Perfect, thank you.
Welcome.
Okay, so there's a question by Ash. It says, we have been living separately since 2016. I've had numerous serious health problems since that time. We have no children. I was widowed prior to meeting my husband. I was financially set. During our 17-year marriage, he worked secretly with our financial planner to move assets into his name and to add his name to accounts held solely by me, making them joint. What can I do to get these assets back? I have had poor health and you are unable to work. So the first part of it is that if you're married, it doesn't matter whose name is on what. Every asset and debt in your marriage needs to be equalized. So even if everything was in your name, that would still need to be equalized. Most likely you're going to need to either do a separation agreement or go to court if you believe that he's going to be hiding assets and not providing them in his financial statement, because then you can make court orders for full and frank financial disclosure. Sash, do you want to add anything to that?
Yeah, sounds good. No. Good job.
All right. I think we've answered Shia's question.
Because he was just live with us. So.
All right, let's go to the next one for now. Is there a template checklist of topics and things to consider when looking at separation?
I think we touched on this before a little bit earlier.
Yeah, I'm looking to divorce my husband and he says he wants to be amicable. Wondering if we can start discussing the relevant topics before engaging with a mediator and or lawyer.
I love that idea. I'm a strong fan of that. I always say as much as people can do amongst themselves in what we call like the kitchen table discussion, that's amazing. It's going to keep your costs down. The more you guys can talk about things, I think that's wonderful, because things like, I'll use the example of dividing household contents, you really don't need to hire a lawyer to do that. So that's something we always encourage your clients to do if it's possible, because lawyers can get expensive, and it's the back and forth that increases, or back and forth correspondence, I should say, that increases legal fees. So the more you can do throughout the process and at the outset, wonderful. And then take that kitchen table discussion to a lawyer, and there's things that you and your ex might not have contemplated at the time of coming to this kitchen table discussion that a lawyer can give you some additional information for. So yeah, wonderful idea, love it.
You can also book up your consultation with us right now. We can start talking to you about it without giving you specifics of what you exactly want, but at least talk about what kind of things you need to talk about with your ex-spouse so that you can start that conversation, and then you can bring it back to the lawyer afterwards. As Sasha said, it's the best way of keeping it the cost down as possible if you've already agreed to most of the issues.
Right, thank you. Next question, specific question. Separated 2017, have not established child support due to him not agreeing with his income. He's self-employed. Also threatened that he will just get me back to me the following year. And I found out other lies that delayed everything. My question is that if I can still ask for back pay in 2017, if ever I went ahead also for court order, which forms and how do you deal with self-employed people who can manipulate expenses towards income?
I'll take this if you guys want. So you can definitely ask for child support going back further, especially if you have been asking for child support since that time. If you haven't been, then it's harder to get back arrears because the judge will say, well, how would they know if they needed to pay if you hadn't been asking for it? But if you've already been asking for child support since then you can definitely bring a court application and ask for what's called child support arrears. Now, the second part of it is a person being self-employed. So the family law really knows that self-employed people can hide money legally when they're doing their taxes. There's a lot of things that they're allowed to discredit in their taxes so that they can write things off. But family law has said that, a lot of that can be applied back in when you are self-employed, when you're trying to decide what someone's income is. The easiest thing to do, even though it's expensive, is to get what's called an income valuation. So once you start a court application, if the other party won't agree, you can still ask for a court order that an income valuation be done. And that means that your self-employed spouse has to provide all of the financial disclosure to a third party who would be hired to do this. And they would go through all of the corporations or businesses in financials and come up with a decision of what the income of your ex-spouse would be. And then sometimes there can be dueling experts on that, but usually only one person will do it. But it is an expensive endeavor.
Thanks, Sam. So the next question is from Diana. And again, it's about separation agreements and whether she should draw their own agreement regarding how property is to be divided and what terms in terms of custody will apply. Question, can we use it as a legal document agreement, or does it have to be signed in from lawyers to make it legal? So we did talk about this a little bit before. Of course, absolutely, like Sasha, Preet, Emily, and I have all been saying, do your own agreement as much as possible. You can have a lawyer draft it for you, but I believe it was Preet who talked about this a little bit earlier about whether or not it stands if it's signed by a lawyer or not, but it is still an agreement. My panelists can jump in, fellow colleagues, if you wish. I don't remember who dealt with this before.
I'll say I always encourage people to obviously get lawyers and to do everything. So sometimes clients will come to us, like I'm working on a case now where the other party really doesn't want to get a lawyer and my client's okay with that, but I'm trying to encourage him to get ILA. And independent legal advice really isn't expensive. What gets expensive is usually it's the first or the most money is spent preparing the draft of the separation agreement. And I think a lot of people have a lot of misconceptions when it comes to the cost of lawyers' fees. And yes, they can be expensive if it's a very litigious file, but for something like a separation agreement, you want that agreement to be binding, especially if there's children involved and there's property involved. So you want to make sure that you are going to walk away from this process feeling confident that if this agreement were ever challenged in the future, that it is going to be upheld. And as I said, I think at the outset, the two most common reasons why separation agreements would get aside in part or in whole, if they were ever challenged, is because one or both parties did not provide full and frank financial disclosure, and one or both parties didn't have independent legal advice. So we always encourage people to get lawyers because you want to make sure that whatever you're signing, you understand what you're signing.
And to tack on to Sasha, if you don't mind,
yeah,
the cost of getting lawyers to do independent legal advice will certainly be lower than if the other party wanted to challenge the separation agreement later on. So it's definitely worth it to get it signed, get your legal independent advice, and do that due diligence from the beginning to make sure it stands.
Yeah, I think Preet said this quote a while back, and it stuck with me, that cheap is expensive.
Yeah.
And that does definitely apply when it comes to separation agreements, because I think a lot of people think, I'll just go the cheap route. There's separation agreement templates online. I think Krisha mentioned that earlier. But those, I've never once had someone give me a template they found on Google. It's never once been great. So lawyers do have a program called DivorceMate, which provides us with a general template for drafting a separation agreement, but every family, every separation agreement is different. So Ryan just said in the group chat, cheap is expensive is 100% my quote. So my apologies.
I was going to correct. Either Ryan's quote or Shannon, one of our old colleagues who doesn't practice law anymore.
I love that. But it's true. So if you're going to pay for something, it's always good to just do it right once the first time and avoid complications in the future, especially when it comes to things like dealing with children's issues and property, spousal support, child support, etc. It's just do it right the first time.
All right, next question. We're almost out of time here, but we'll take a few more questions here. If my ex is in contempt of things agreed to at a settlement conference and a final order has been made, can the case be reopened and all agreements stayed? Hence starting over again as my ex has refused the access agreement, among other things. I just need to know if I can reopen my case based on the fact that my ex has re-engaged on every aspect of our settlement. That was April of 2018. So
basically they've breached every term of the agreement.
Yeah, if there's a breach of every term, then yes, you can bring a motion to change if there's a final order in place. And perhaps the settlement conference was the reason the final order is in place. And you both came to a mutual agreement that you guys were going to agree to those terms. However, simply put, you can bring a motion to change, and I would advise to book a consultation to discuss how that agreement would come to be and how that motion to change would come to be given the specific circumstances of your case.
There's also the option, if you want the final order to continue and she's just not following it, you can bring a motion for contempt. Correct. Instead of bringing in a full other matter, so a motion to change is like starting a whole application over again. If it is that you just want the orders to be complied with, you can bring a motion change, which is just, or a contempt motion, which is just one court date.
I believe that was from Dave Brown, and it was the same question we kind of addressed earlier on about whether or not it was to set aside the motion or set aside the order or to enforce the order. So like Emily said, there's two options based on what it is you're looking for.
All right, I think we're almost up on time. I'd like to discuss a few things before we do turn off the webinar. If your question did not get answered today, you can book a free consultation. It would just be one-on-one with us. It would be actually a more productive conversation because we could ask you questions and you could return comments to our responses. So if we didn't get to your question, please visit us at kpalawyers.ca and book a free consultation. Before we head out, I just wanted to let everybody know that we accept legal aid matters. We also have relationships with financing institutions. So if you own any assets and you cannot afford to pay a lawyer because there's simply no cash on hand, or that you may be a stay-at-home parent and you've never had a job, but you do have matrimonial assets. So we do have financing options available for you. We take legal aid, we do limited scope retainers, which we find assist a lot of our clients. And if you just reach out to us, we'll be able to set you up with the best possible method of doing business with us and allowing us into your life and allowing us to help you in your life. So again, I repeat, if you need questions answered, just book a consultation with any of us. Just visit our website and you'll see our profiles there. You can do a little bit of researching about us, what we do, how we are. We are how lawyers should be. That's what our website says.
I believe Ryan will be sending out an email to all participants as well with the link to book consultations. So You will be provided with that directly as well.
Yes. And we just want to say thank you very much for spending your evenings with us. Your evening, I should say. All right.
And that's it.
Have a good one. Thanks for
Bye,
joining.
everybody.
Bye.
Thank you.
Bye.